Hey everyone, welcome back to Legal 252, Intro to Civil Litigation. We'll pick up where we left off the week before. Sorry about the time conflict, but okay, we're going to go ahead and get started. So prior we were talking about defendant's answers, right? So we learned how to draft a complaint from the plaintiff side, right? Genocide. And then we learned how to draft a defendant's answer from the other side, right? So, and today we're going to learn how to draft a demurrer as well as go over what motions are, right? So those are other options that defendants have to actually respond to the plaintiff's complaint, and they have to file it within 30 days in in that courtroom, right? So let me go ahead and share my slides. Start with nuance so I can share you. Okay, so these are up on Canvas as well, but I know some people prefer it in attached in the chat box. Okay. And share my screen. Okay, so a demurrer is another response a defendant could file versus an answer, right? It's very similar to an answer. It's kind of a cross between an answer and a motion to dismiss, right? So a demurrer, and these are rarely used. There's not even a chapter on it in your book. It's just that I figure I should add it in because it's possible an attorney you work for might want to actually draft one of these and file it instead of a defendant's answer, right? So demurrer is only used in the state of California and Virginia these days. It's not really commonly used anymore in any jurisdiction. It's not used at all on the federal level, right? Because a demurrer is very similar to a motion to dismiss, right? So you could literally just file a motion to dismiss instead of filing a demurrer. And a demurrer is also, it's hard to prevail with a demurrer. And let me explain why, right? So in a demurrer, it's called a so what pleading, right? Even if everything in the complaint is true, the demurrer basically points out that even if everything the plaintiff says, I did do all those things, I did not break consumer warranty protection laws, right? Or it doesn't matter if everything is in their statement of facts is true, they still didn't prove that I broke any kind of law whatsoever. Right? That's what it basically is. Like, for example, if the complaint says someone yelled at me, someone humiliated me, um, if they're not specific about, harassment, intentional infliction of emotional distress, right? Yelling at someone and embarrassing them are honestly not violations of any civil or penal code, right? So that's what a demurrer would be. They would be like, yes, I yelled at her. Yes, it was embarrassing, but those things are not illegal, right? So this complaint should, or this case should be thrown out. So a defendant does not necessarily need to bring evidence to fight against the causes of action brought against them in a demurrer, right? So in the defendant's answer, right, we had to address, okay, let's say the plaintiff filed the complaint and had some exhibits attached to it, right? Some police report, some I'm trying to think what maybe a notarized witness testimony that was validated, right, or authenticated, right? And so in the defense answer, we have to address those pieces of evidence, right, and say we have our own pieces of evidence forthcoming or attached herein. We could prove that we didn't do those things, right? A demurrer doesn't necessarily, with a demurrer, you do not have to worry about exhibits, evidence. You can, it just strengthens your demurrer, but really the demurrer attacks the language. It attacks the poorly written citations in the complaint. If someone is representing themselves in the complaint, like the legal citation, it's the wrong citation. They're talking about tort, personal injury. This is about harassment, right? And it, oh, sorry. Yes, that's why managers at work yell because they can. And I don't want to support that, but I mean, possibly, right? Possibly that. And I think employment contracts usually also, they say you can't even sue your manager, right? It would have to go to arbitration probably. Uh, do we file the demurrer and the answer? Oh, Samra, you choose one or the other. And 95% of the time, 98% of the time, your boss is going to have you draft a defendant's answer. But a demurrer on a rare occasion, if your boss definitely feels like the complaint is weak, the language is vague, there's a typo in the citations, your boss will probably suggest you file a demurrer, right? So it's either one or the other, but more than likely it'll usually be an answer. And if it's the federal level, yes, it'll always be an answer. We don't Demurrers are not used at all, not accepted at all as a pleading on the federal level. Just the demurrer altogether will throw. It doesn't guarantee. It could be the demurrer might not be strong enough to throw out the case, Samra. So it's possible that it will still go into discovery after the demurrer is filed, right? It doesn't guarantee anything. Be filed later in the case. Trying to think, Christine, if I've ever seen it filed later in the case. I'm gonna have to get back to you on that one because I've never really seen it once it gets past the discovery, once it gets to the discovery stage from the pleading stage, which is when the complaint is filed and the defendant's answer is filed. I don't know if I've ever seen it filed later on. A motion to dismiss can definitely be filed later on, which is very close to a demurrer. I'm sure I'll have to get back to that. I'm doing a little bit of research because, like I said, it makes it from pleading stage very early on to discovery. Right, discovery is 10 days after defendant is served. It's usually a motion to dismiss if you want to try to dismiss it. Right, a demurrer is like a motion to dismiss, which is why I don't even know why California still has it. Oh, and Virginia, right? All the other states don't use it. Federal level courts don't use it because what it's supposed to do is attack a technicality in the complaint and have the case thrown out, right? So now I'll get back to that. Can it be filed later? Filed later, or are we only allowed a motion to dismiss? Let me double check that for you. Because like I said, in your career, you probably will rarely see this. You'll more than likely see an answer versus a demurrer. Let's see. More appropriate, less confusing. What are the odds that a demurrer would be more successful than a motion? Have you seen a success rate? I don't know about a success rate, but I've seen a demurrer done rarely, and it normally will work against a plaintiff that represents themselves. Also, because more than likely, if you hire counsel, they're not going to draft a poorly written complaint, right? They're going to get the citation correct, the jurisdiction correct. It's going to be proofread by an attorney and a paralegal. So, what are the odds that a demurrer is more successful? If your boss, okay, so a demurrer could work if your boss is really savvy at pinpointing a technicality in the law. So it will, I'll show you guys an example. We're going to do one together. We'll still use the Jenna Honda case, but let's pretend like the plaintiff was poorly drafted and Jenna represented herself, right? So that's the exercise we're going to do. But a demurrer can work if your boss is savvy at finding a technicality in the complaint, right? Which means, let's say in the complaint, in the statement of the proper legal citation that the defendant supposedly broke a law, right? But then let's say there's three elements that have to be present for the defendant to break the law, right? A, B, and C have to be present for the defendant to have broken a law. And if in the statement of facts and in all the causes of action, the plaintiff only mentioned how they broke two elements, A and B, right? There's no mention of how C was broken, right? How the third element was broken, and all three need to be present for there to be an actual case for defense. So in a situation like that, your boss, if he catches that, he or she or they catch that, you could absolutely attack it with a demurrer, and that could be enough to throw it out. But here's the downside of that, right? A lot of times, if a judge sees that plaintiff's representing themselves or for whatever reason it was poorly written, they could give them the opportunity to amend. That's why this one is less likely used. Don't get me wrong, there are some judges that don't give you any inch to amend anything and will just throw it out. But that's also why a demurrer is rare, right? If there's a typo in there and you're representing yourself, a judge will probably let you amend it. A lot of times they do allow both parties to amend their pleadings, right? If there's some type of typo in it, on rare occasion, I mean, there are some judges that don't want to waste their time, but they probably would let a plaintiff representing themselves amend it. That's the only issue I see with a demurrer. Yeah, demurrer can definitely point out a technicality in the law and have the lawsuit dropped, right? But usually, oh, that's good. What is the petition that answer the pleading, but also attacks the plaintiff, arguing that rather than the defendant being guilty is what is the petition that answers the pleading? Plaintiff arguing that rather than the defendant being guilty is actually the op. Oh, do you mean so either defendant's answer or demurrer? Samara, is that what? Oh, I've never heard of that term actually. Contra attack the pleading. Oh, plus both parties are allowed to file a petition to amend. That is also a filing you could put in if it is pointed out that there's a typo in there and the court could grant it. So that's why this is less used. Oh, contract. I've never heard that term before, but let me look it up. It's possibly similar to something that we have as well. It just might be under a different name. Yeah, because both parties could, oh, it's in Portuguese. Both parties could petition to amend as well, right? If not, the judge allows them to amend. So basically, Demurrer is winning on a technicality, right? Poorly written complaint, or very weakly done, or in the statement of facts and in the causes of action, even though you listed a law here, right? The defendant clearly didn't break every element that was necessary to be guilty of something, right? The demurrer gets a hearing 35 days after it's filed. So that's why it's kind of like a motion to dismiss, right? So a motion, when one party, either plaintiff or defendant, want to file a motion, it will be given a hearing in front of a judge. And then the judge will come up with a resolution after that. So a demurrer gets, so we have to wait on this. So defendant's answer, normally after the defendant files their answer, discovery starts, right? But with the demurrer, you're actually waiting for a hearing with a judge. So that's what sort of is different about it, right? And then the judge will meet both parties in a demurrer hearing, read both the complaint and demurrer's arguments, and render a decision. So sometimes the decision on a motion or a demurrer hearing will come after the hearing, right? Nowadays, it's pretty easy. You guys could log in. Well, I guess it depends which Superior Court it is. You should be able to log in these days and see the judge's decision before we had to call a number during a time frame to find the judge's decision, right? If they didn't make one right then and there. So the word demurrer means to object, right? A demurrer is the document that makes the objection, right? Lawyers informally define a demurrer as a so what pleading, right? Even though everything they said in the statement of facts is true, everything in the causes of action is true, but there is no proof that a law was broken by the defendant in any way, right? Or there's no allegation that the defendant broke a law in any way. So that's what a demurrer is, right? We file it, we wait for a hearing, and then the judge will make a decision on it, right? If the demurrer is granted, which means the defendant is correct, the case is thrown out. If they side with the other party, right, then they'll continue to the discovery stage. So it makes it past the pleading stage to the discovery stage. So the word, I'm going to mention that. So you're basically trying to get the defendant off on a technicality, right? Not necessarily on evidence, right? You can only use objective facts and evidence, right? Nothing subjective, which, well, that's not, well, like I said before, in a demurrer, though, normally you won't need to really submit that much evidence. You're attacking the complaint itself. right? So I'm just gonna, maybe I'll leave that out because you could also use that in a defendant's answer, objective evidence. So even if everything in plaintiff's allegations is well written, even true, right, the defendant can still say, so what? Oh, we'll get to that example later. So I'll have you guys do a practice one, but for homework, but we're going to do one together too. Oh, countersue. Okay, that's what you meant. Samra. So if you wanted to countersue someone, that countersue would be mentioned in the defendant's answer. So in there, when you're basically saying counts 1, 2, and 3, we could prove forthcoming with evidence that those things aren't true, right? And we would like to count. So you would put that in defendant's answer. You would countersue in the defendant's answer and say, and basically say, and we would like to sue the plaintiff for X, Y, and Z, right? Because yeah, that's common. If both parties are in a dispute, it is possible for the defendant to not only try to get the case, well, not necessarily try to get the case thrown out, but turn the blame around on the plaintiff too. So in that situation, both parties, the burden of proof is on both of them, right? They're both going to have a presentation of evidence for sure at trial if there is one. So that's, yeah, a defense answer. Countersuing would also be in the defendant's answer. And you could also cross claim too, right? Let's say you have two defendants, a plaintiff is suing two defendants together, right? It's possible in each defendant has their own lawyer. They could have a joint lawyer if they wanted to, but if they don't trust each other, they could have their own individual attorneys as well, and they could countersue the plaintiff, or they could cross-claim each other, which means also bring suit against each other. Like, and this will all be seen in one trial, right? Because it's one incident, but blame and culpability and who pays the judgment at the end of this will be determined based on who's most responsible. Is it both defendants 50-50, or was one defendant more responsible, like 90-10, and have to pay the plaintiff? That's going to be mentioned in a defendant's answer. Yeah, if you want to countersue or cross claim. Can an answer to a lawsuit be a response saying it's a frivolous lawsuit? Yes, Rebecca, it can. Yes. So, especially if the complaint was not attached with any evidence, and especially, or if it just has that little blurb in there, evidence forthcoming, yes, you can say it's a frivolous lawsuit. Absolutely. And if you have proof of it too, a frivolous lawsuit could also be like if a plaintiff tried to sue a defendant for $40,000 because of this car accident, and the defendant could prove that they already wired them $40,000, right? So showing that receipt could make it a frivolous lawsuit. Yes. And you could have it thrown out. Yeah. They would call it meritless, like meritless claims. Yeah, that has no merit to the cause of action or in the statement of facts. It's all there's no evidence in there. They're just, well, it could be well written, even if it's a complaint that's meritless. But more than likely the complaint comes with no evidence and no evidence is submitted, right? To sort of give the court some semblance that this could be true. So before the hearing, right, both parties must meet at least 5 days prior. Right? Ideally, a judge is hoping both parties will work it out in an alternative dispute resolution. So a lot of times, whenever you get the court involved with a demurrer hearing or a motion hearing, especially in California, part of California rules of civil procedure are to meet and confer first. And the judge will ask, did you guys meet and confer first 5 days prior to straighten this out between the two of you? Because if they can't straighten out 5 days prior, they would just cancel the hearing, right? Clear up docket time. And so the judge can see some other hearings on other things. Because ideally, they don't want to get involved. Well, I guess a demurrer is fine, but then I'm thinking of normally when you file a motion to compel, we'll get to that later, because one party is giving you a hard time not sharing evidence, right, in discovery. Normally the judge doesn't want to get in the middle of that, but a demurrer will normally just throw out a case or advance it to discovery. I already mentioned here, California Rules of Civil Procedure 2016.040 requires that parties meet and confer reasonable and good faith attempt at an informal resolution, hopefully right before the hearing, because that's what they do prefer. Okay, so I'm gonna go over. Oh, well, first, I wanted to go over complaints. Okay, so, 1 second. Okay, I just wanted, I started correcting everyone's complaints, and I just wanted to point something out when I was correcting everyone's complaint. You guys did it right, jurisdiction, and where it says cause of action, right? If you only have one, you could just put cause of action. I noticed a lot of you guys put first cause of action because that was in the template. Sorry, I should have been clear on that. But I didn't dock anyone points because it's kind of just a minor thing, and it's good to know, right? Is to put just cause of action if you only chose one. First cause of action if you have at least two, right? First cause of action, second cause of action. And I also noticed some of you guys left the bold second cause of action in your complaint as well. You could just delete that if you only used one. I just noticed that when I was correcting it, but I didn't dock anybody. I just put it in the comment section to remember to delete it. That's okay. Okay, so for a demurrer. So I wanted to do a demurrer exercise. Okay, we're gonna go back to Jennifer's Honda just because we're familiar with that case, and this will be the last time we use this case, right? We'll move on to a new case for homework. Okay, so for this situation, and I just wanted us to practice drafting a demurrer, right? So I gave you guys this complaint, right? So I know I read a lot of your guys' you guys all correctly chose the right citation, very descriptively, drafted your statement of facts, put dates, put the cost of the car, right? $17,000 car, everything, right? But let's say all those things were omitted, right? And let's say this was a vague, overly broad, drafted complaint, right? That's what we would attack if it was a demurrer response versus a defendant's answer, right? So I've been put in parentheses like what's missing here. So plaintiff purchased a Honda Civic from Honda of Ceremony, right? You could already say that this is vague, right? Are we even sure that it was, said defendants dealership, right? Because date, price, is it new or is it used, right? Location info is missing. Civic began stalling, including while driving at night on freeway. The stalling has continued to happen monthly, right? Well, could you give specific dates regarding that, right? And they weren't let's say, they weren't documented or sent or reported to us, right? So we could help her. Let's see, the vehicle was out of service for some time, right? The dealer never helped. In your demurrer, you could always say, dealer has a protocol for always helping, right? And she wasn't specific about the time, right? The vehicle was out of service for some time. Could you tell us how long, right? Regarding that to see if we actually did break our personal contract warranty as well as, broke the Beverly Song Act as well, right? Plaintiff notified Honda, but dealer refused to replace and or refund, right? In writing, in email, right? Proper protocol is listed in our the contract that Jenna signed, right? So those are some holes you could poke at it, right? And as well, defendants have violated California consumer warranty laws, right? I noticed how I took out the citation, I took out the name of it, the title of it. It's here, right? But there is no number. There is no citation. That's another main one. I mean, it was mentioned up here too, but a court's not going to run to Google which act it is. Like, that's fine if you want to give the name of the act, but you have to give the legal number, right? That's what they're looking for. What is the abbreviation in California code and what's the section? That's what they're looking for. They're not going to go running looking at the Consumer Warranty Act, right? That's our job to provide them with it. And then so you can always attack that. There's no citation in here, right? And Oh, in a demurrer, you don't necessarily, so this is the complaint, right? Sorry, this is the complaint. In a demurrer, you normally don't have a prayer section. You're the goal of a demurrer is to get it thrown out, right? So this is the sample complaint I would want you guys to draft a demurrer in response to, and then we're gonna go over it together. But here, let me show you guys what the template would look like if it's a demurrer, right? So I'm not sharing my screen. Okay, so the sample weekly written template is up here, right? Because the ones that you guys drafted were perfectly well written with the actual code that we can't file a demurrer response to, right? You guys did a good job with that. A demurrer template normally comes with two sections, right? The first one is really just like a title page. You don't have to do too much to it. You just sign your name to it. This is what it looks like. And share and reshare. Is it freeze? Oops. Okay, I'm sorry. This one is the wrong attachment. Let me fix that first. Well, let me show you guys what it looks like, but it looks like my attachment didn't go through. Let me show you guys what the demurrer should look like. What? No, don't tell me it did not save. One second. I'm so upset. Okay, it did not save my changes. But let me just show you what a demurrer looks like. And give me a quick 5 minutes so I could tweak this again. It did not save for some crazy reason. All right. So demurrer looks like this, right? It has, the same pleading paper. It has the caption on top, right? And this section above, right, you really don't have to change anything. It's to this honorable court and to all parties in their council of record. Please take note that on November 30th, 2023, there may be a matter heard in Department 1 at the address here. So, normally the party asking for the hearing, which is the defendant, in this case, it would be the defendant. Defendant or defendant's counsel will have to go online and see when a demurrer hearing is available, right? Same thing with a motion. You would normally go to the website. You might have to call a phone number, or you could actually see the calendar on a portal and see where your department has an opening for a demurrer or a motion hearing, and then you would schedule it, draft these demurrer papers, file it, and then you have to serve it on the other party, right? So then they're aware that okay, a hearing is coming up in 35 days. They also have the right to file a response to your demurrer answer as well, and prepare for this hearing that's coming up. Okay, so this, you guys can see this, right? So yeah, so that's what this section up here is, right? It's just to let the other party, the plaintiff, know that we're going to be seen at a hearing at this location here at this time, right? And then you address first and second cause of action, or if there's only one cause of action, one cause of action. And you're just basically say this demurrer is brought, let's say, to the actions complaint, as each and every cause of action fails to state sufficient facts sufficient to constitute a cause of action under California rules of civil procedure. Right? This is normally template language. The template I give you, you're not going to have to worry about filling this out. I just want you to know what's in it. And then it says a memo of points and authorities. So a memo of points and authorities will be part two, will be the second portion, and under the memo points and authorities, you'll basically give the law, you'll give the law that we're addressing. And for example, the Beverly Songbird Warranty Act, and then you'll give the code, right? And then you're going to cut and paste the code into the memo points and authorities. And you're going to explain why the defendant did not, according to the complaint that was drafted, the language in the complaint does not describe how defendant allegedly broke this law, right? Because there are no dates in there, there's no specifics. It's all sort of vague allegations with no specific statement of facts proving that potentially the defendant broke a law. Is this the way a standard complaint looks like? Oh, complaint. Here, let me. If it's customized, yes. So here, let me bring this back. And we haven't even gone into fillable forms yet, but yes. So standard customized complaints do look like this, right? Jurisdiction is mentioned, cause of action, and then the statements of facts underneath it, and then the prayer section. So yeah, you need all three of those things for it to not be thrown out. Have I seen it drafted differently? Yeah, sometimes attorneys do a statement of facts first. So it's bold in the middle, statement of facts first, and then cause of action afterward. Then you specifically address the law, describe the law a little bit, maybe cut and paste it in there, and then describe, okay, from the statement of facts, this is why the defendant broke this law. So I've seen it separated. I've seen it statement of facts underneath the cause of action itself, right, underneath the code itself. I've seen it done that way, but that content does have to be present, right? But jurisdiction is usually first. Yeah, cause of action, statement of facts, and then prayer section. That's standard for a customized complaint. There are downloadable, fillable forms you could normally get on the Superior Court's website. On the federal level, they definitely I like their templates a lot better. It even says like how many, they even sometimes give affirmative action, affirmative defenses on there as well. Yeah, they'll ask you, they'll have a box for literally everything. And they'll even describe what goes in each box as well, which is normally the jurisdiction. Yeah, the causes of action, and then the prayer section. Yeah, so they guide you a little bit better on with the federal forms. And I can give you guys links to what that looks like too. But it's just really helpful to know how to draft these from scratch. That way, if your boss, like you work in the field and they ever ask you to just pull it from the website, it's 10 times easier for you, right? But if you only know how to fill out those forms and you know how to customize it, that could be harder going the other way. But yes, so, oh, sorry. So customize means we drafted all of this from scratch, right? We basically filled out all of the jurisdiction. We had to figure out like, okay, well, what are we going to write in the jurisdiction section, right? Okay, Honda, the dealer is in San Mateo County. So that's why we're going to explain why we're choosing San Mateo. Jenna Mitchell lives in San Mateo County. That's why we have to draft it from scratch, is basically what I mean when it's customized. It's drafted from scratch. Cause of action, remember, we had to look up these laws ourselves. And then we had to describe how the defendant allegedly broke those laws. And we typed all of that from scratch. Same thing with the prayer section, drafted it all, right? Let me see if I could show you guys. Show you what like a complaint looks like. Okay, so let me show you what a template looks like. I think I don't know if I showed you this before. Might have been another class, but this is what a fillable form looks like. So I always use the federal level just because I think the federal fillable forms are easier to follow than the Superior Court ones, but every Superior Court should have templates as well, just because a lot of people try to represent themselves, right? Especially in civil court because it's expensive. And this is normally what it looks like. Syria has a space for a plaintiff, a space for a defendant. It even asks you right away if you want a jury trial or not a jury trial, right? And then it makes it easy for you, right? If I list all the plaintiffs, it gives me a space for all of their contact info versus if we just had blank pleading paper, right? We don't really know what goes in there. Like they literally guide you through all of this. They even give you spaces for extra defendants. And they even ask you about jurisdiction, right? Why are you bringing it to a federal jurisdiction? Is it a federal violation of federal laws? Are plaintiff and defendant from two different states? Basis for jurisdiction, and then you would explain it here, right? And then they basically give you a space down here. State. So what are your claims, right? They give you a box, and then you can put the law in here and describe how the defendant allegedly broke the law, right? And then relief. They even have a space here, a prayer section for you, right? So you know like what goes in this, and then this is all signed by the attorney. Yeah. So see how this is easy if you already know how to fill it out, customize or build it from scratch. Like I thought that filling this out was easy when I started doing IP litigation versus, more local state when we had to customize it on pleading paper. I thought this is a breeze. It lines it up, even the format. Like I don't even have to format anything, right? It's all fillable boxes. Oh yes, Janelle, you could absolutely use the pleading paper that we use in class. Yes, that organization is totally fine. If a demurrer is submitted and granted, can the plaintiff refile with updated or corrected information? It depends, Maddie. So like if the judge grants the demurrer with prejudice, that means case is closed, right? If they grant the demurrer without prejudice, and they also, say they allow or they allow amendment of the complaint, then you could keep the case going, right? But if they grant the demurrer, which is basically a motion to dismiss, and they grant it with prejudice, right? That means it's closed and it's locked for good. That means the plaintiff can't refile it, right? But a judge can give a time frame for the plaintiff to amend, which is why demurrers are not common. Um, or they could dismiss it for now without prejudice, right? Without prejudice means they are giving the plaintiff a second chance if they want to file it correctly, right? With prejudice closes it permanently, and then without still gives an opportunity. Normally, if you file in the wrong jurisdiction, it's dismissed without prejudice. They're giving the plaintiff a chance to figure out, okay, what's the proper jurisdiction to refile it again. Where can we find the link to the fillables? Oh, here, let me give you the link right now. This is for federal, but if you're, I might need a second to find it on state. And it depends which superior court it is. If you tell me which superior court you're interested in filing in, I could find it because every website is different and they update it often too. So the user interface changes. Superior SF or Oakland, Alameda County. I could look for it for you, and I could actually post the links on if people are curious. Is Alameda? Okay, I could look for it for you. Yeah, there are fillable forms. San Mateo County. Some are better than others, though. I have to be honest. But I really like federal ones because they're like very easy. Right? I was surprised at how easy this was to fill out because I started from building it from scratch, from customizing it. I think it'd be great to see those. Oh, yeah, of course. Sure. Okay. So, do you guys want to see? I could put all the Jenna Honda after I've graded everything with complaints and answers and demurs. I could fill out the templates and post it in the answer key too, just so you guys know what it looks like both ways. And both ways are correct, right? It just depends. Let me put that templates and custom answers, just because you don't know what your boss is going to ask you to do. Sometimes they'll ask you to draft it from scratch. Sometimes they'll just tell you to pull it from the website, right? And normally you're representing yourself, probably pull it from the website. It's just easiest. You don't even really have to format it. Okay. Rebecca, yeah, once you fill out these boxes, you just print a PDF it, and you could send it to your e-filing vendor, or if you file it yourself in-house, or if that court wants you to print it and turn it into the court clerk's window, yes, that's all you have to do is PDF it or print it out and file it. Either paper file it or e-file it. Just give me a second here. Actually, my templates did not save. Let's see if I could find a better. Okay, so I want you guys to look at a demurrer. And a demurrer, I think I already showed you guys, right, what the first page looks like. Let's go back to that first page and then the second page. Okay, so the first page really is just a transmittal page, right? So I already showed you guys what this looks like. Demurrer page 1, right? So in terms of a template, right, I really am just going to ask you to sign it down here, right? Just give me like 5 minutes to fix this because it didn't save my changes. But the second page of a demurrer is what you want to focus on. So that's where we actually give our arguments, right? So the second template, memo points and authorities in support of defendant's demurrer, right? So you'll normally give a factual summary of Jenna versus Honda's case here, right? You have to tell the court what is the overarching legal question in this case, right? As defendant, if they broke the consumer warranty laws in California, right? So you would describe it in this section here, and then down here, you would actually cut and paste the law, right? So I cut and pasted it here for you guys down here. And you notice how I have 1, 2, 3, all 3 sections here, right? You would have to cut and paste the section pertaining to this case, right? Like for example, if I just, let's just, for the sake of argument, because we are always pressed for time, well, let's just choose this first one, right? You would cut and paste 1793.22 in here, but only the sections that we'll be addressing that the defendant broke, right? Because sometimes these sections are pretty lengthy, and maybe only section A refers to the defendant, B, C, and D do not, right? You don't want to cut and paste the whole thing, just the part that you're addressing that the defendant broke, right? So you would cut and paste it just like a complaint, right? Bold in the center, and then cut and paste the section that it's pertaining to, and then what you're going to do is put a question underneath it, right? Did plaintiff properly state in detail how defendant Honda Inc. broke consumer warranty laws? So you want to put a question and then explain it with an answer. No, defendant is not responsible for breaking consumer warranty laws because the language in the complaint is vague, right? Vague, insufficient, overly broad. Everything in the statement of facts is true. However, no law was broken by the defendant. That's normally what you're going to argue in a memo, points and authorities, right? And I'll actually give you guys a chance to do that right now. Let me just upload this template for you. Sorry, didn't save my changes, so I'm gonna have to change it now real quick. You guys can start filling it out. Okay, so I just published this exercise up on Canvas, right? Here's the sample complaint, poorly written complaint, right? And I underlined and bolded all the mistakes that say Jenna made in the complaint, right? That you could use in your Demurrer attacking her work. And if you download template, don't worry about the caption on top. You could, well, you could change it to Jenna and Honda. Sorry that my changes weren't saved um, in my template. It looks like it was overwritten. But anyway, you could go ahead and cut and paste the sections that you guys use. You could use, just this section, or if you wanted to go 93 and 94, that's fine. And then cut and paste the sections that you're arguing. And then did plaintiff properly state in detail how defendant Honda Inc. broke consumer warranty laws? You could use that question. You could just unhighlight it. But then I want you guys to explain, no, defendant did not break. We're playing devil's advocate here, right? You're trying to get this thrown out on a technicality, right? You could describe all the technicalities in that poorly written complaint and say why this isn't a viable lawsuit because the complaint was poorly written. Okay. Obviously, that doesn't happen often, normally only when someone's representing themselves, right? Or if your boss can pinpoint a technicality in the complaint, right? If for those of you who hopped on late. So I was also mentioning, so a demurrer instead of a defendant's answer was used to in response to a complaint when the complaint is weak, right? There's no citation, it's the wrong citation, or it's just poorly written, and we could attack that on a technicality to have the whole case thrown out. Or sometimes if it's a well-written complaint, sometimes your boss will notice that according to this law, elements 1, 2, and 3 have to be broken in order for the defendant to have actually broken the whole law, right? And if they're missing element number 3 in their statement of facts, in their causes of action, and they didn't mention any allegation as to how element 3 was broken by the defendant, that could also get the case thrown out, right? Because let's say you needed all 3 for a law to be broken. So that's normally what it looks like. So if you guys wanted to start, you could just do a summary on the Jenna versus Honda case, right? And then cut and paste this law in here, describe it a little bit, right? And answer this question, right? How is the defendant not responsible for breaking consumer warranty laws based off of poor language? Poor language, no citation. You could also use that as well. So we're attacking the language, right? Technicality, language, and I'll give you guys maybe 10 minutes to start working on it, or I'll come back if you need 15, but then I'll help you guys formulate a response, right? I just want to see if you guys want to go ahead and get started on it first. And I'm using this case again because we're used to it, but for homework, I'll give you guys a brand new case. I swear, this is the last week we're going to talk about Honda. Okay, I'll be back in about 10. If you need more time, that's fine too. You'll need a little extra time. Otherwise, I could just give you guys an idea of roughly what it would look like. Okay, so let me, now that I was able to had time to tweak the first cover page, and it's now up in the prompt too, right? How do you guys fill out part two? The first page is really just a transmittal, but now that I was able to clean it up, this is normally what it looks like, right? Superior Court of San Mateo County, Judge Mitchell and Honda, right? And then notice the document that it is, right? Notice of demurrer and demurrer of defendant to complaint. No, it should say education. So it should say consumer warranty. It should say consumer warranty, right? So it says, please take note that on date, right? And the date that we normally contact the court, ask them for a hearing date first before we serve the other party and file these documents. We put it in here and then address of the court. Right? And then this demurrer is brought, and this is normally normal language that you would use, right? If you're attacking the actual weakness of the complaint, right? This demurrer is brought to the cause of action of a plaintiff's complaint, as each and every cause of action fails to state sufficient facts sufficient to constitute a cause of action. So that's common to use the word insufficient or insufficient, right? Pursuant to California rules of civil procedure, right? This demurrer is brought on the additional ground that those causes are uncertain, right? The terms are uncertain within the complaint, right? This demurrer is based upon the notice of demurrer, which are these two documents for filing. The attached memo points and authorities, judicial notice submitted here when don't worry about that. We're not drafting that right now. Judicial notice just means we're going to notice and notice. We're just telling them when the hearing date is, right? And the documents of records are herein. So that's just how the first page looks of a demurrer, right? See, looks very similar to a defendant's answer, right? And then the second page that I had you guys fill out. Oh, I'll explain that. Okay. So go back. Yes, I think it was Samra in the chat box. When you could always put pursuant to California rules of civil procedure, and you could put the specific citation. That's totally fine. When you're addressing, like, well, what section or code regards demurrers, you could put the code in there. That's totally fine. If you guys want the extra mile. Why does up here it say demurrer? Yeah, it is going to say motion and motion too. So on the documents, it says notice of demurrer and demurrer, and it's going to say notice of motion and motion, just because this first cover page is a notice, right? These documents will be served on the other party. In this case, it's going to be the plaintiff. So just like a summons and a complaint are served on the defendant, right? So now they know by a process server, they know that they're being sued. This will also be served on the other party, right? So they know that the defendant wants a demurrer hearing, plaintiff and their counsel will have to appear and also prepare for it. So the notice is the first page, giving the date and the address, the date and the address of the hearing. So that's the notice of demurrer. And the demurrer is the section I asked you guys to fill out. So demurrer of defendants, to defendants, I'm sorry, that's to plaintiff's complaints. To plaintiff's complaint, that's the actual section you filled out, right? Attacking the technicalities in the language of the complaint. You could also, that's what the exercise is, right? To attack the specific weak language in the complaint. You could also attack the law. Like I mentioned before, if your boss is super savvy at finding loopholes in the complaint document, that could be what a demurrer also attacks as well, not necessarily just weak language. Sometimes a complaint is well written, but if your boss is savvy enough and they catch a weakness, catch a loophole in the law, an element is missing, perhaps in the complaint, you'll also mention that in the demurrer. I get it. There should be a comma there for clarity. Oh, yeah. I mean, it's up to, since these are customized, you could always put like a colon or something like that. Yeah, that's, I meant attack the language. So, oh, the evidence. Yeah, you can. Yeah, you definitely can. Let's say the plaintiff filed the complaint, it had a police report attached, right? You demurrer could attack both, yeah, the evidence as well as a technicality in the complaint, right? Yeah, you can, but a demurrer is normally used when we have enough to where we could have this thrown out just on the language or a technicality in the law. Yeah, but you can attack the evidence as well. Yeah, you would specifically if plaintiff didn't attach the purchase of the vehicle agreement. Oh, good point, Sarah. If they say, please see exhibit one herein, and there is no exhibit one, yeah, you could definitely go after that as well. Right? If they put in the complaint evidence forthcoming, then they do still have time to submit that as well. I think that they have up until the defendant also responds with an answer. So yeah, that's why this first page is the notice, and then the second page is the demurrer, right? So let me go ahead and bring that up. And you'll see the same thing in motions too. It'll say notice of motion and motion. Unfortunately, it is confusing. Memo points and authorities in support of defendant's demurrer. Okay, yeah, that's correct. So you would put factual summary, right? You would just describe the scenario here, of course, detailed as possible. But notice that in the complaint, right, they vaguely said California's consumer warranty laws. So it's definitely up to you if you just want to attack, well, what consumer warranty laws are they addressing, right? The complaint didn't give a citation. So in this section, you could literally just put that language there, like California consumer warranty laws were addressed in the plaintiff's complaint, but no proper citation was provided, therefore not sufficient enough to move forward with this lawsuit, right? It's meritless and should be thrown out, right? But let's say that they did mention the code, right? They just didn't describe it correctly, or the language in the complaint was weak, right? So you could also cite it and cut and paste the language in 1793.22 and answer the question, right? Did the plaintiff properly state in detail how the defendant broke consumer warranty laws, like right here, right? Because you have to put the definition up here so the reader, the judge, or the clerk could refer to it, I guess you could say. So, but you would put down here, because the language in the complaint is insufficient, does not allege any laws were broken by the defendants, right? But no specific dates or details regarding purchase, um, purchase location, or because I'm referring to the complaint, right? In the complaint, there were no dates. I took out the price, I took out the dates, because that's what it could look like, is just vague allegations, right? No specific dates, detailing regarding purchase location, or if a car was new or used, right? In Brazil, we don't have the forms available on the district websites, rather. Oh, you guys customize everything, Sam. Yeah, a lot of times people represent themselves, federal or state, right? Yeah, so I think it's more common now that superior courts and district courts have fillable forms. Can you upload this one file? Oh yes, absolutely. I'll give you guys this template. Even though it's a working draft, I could clean it up a little bit and upload it for you guys. So let's see. No, defendant is not responsible for breaking consumer warranty laws because the language of the complaint is insufficient. You could use language like overly broad, or and does not allege any laws were broken by the defendant, right? Or no specific dates or details regarding purchase location, right? In the horribly written complaint that I gave you in this example. What did she buy it at Honda Cermonte or did she buy it at another Honda? Right, there's no actual address, and you want to be as detailed as possible in a complaint. Price tag of the car, right? You know, yeah, details about the address of the actual location of the dealer, or if the car was new or used, right? That's absolutely important. When she brought the car in to be inspected, the first time it broke down, what, like, basically, usually a statement of facts. I know I give you guys really short snippet examples in class. A statement of facts could be pages, right? She could have documented in her complaint every time she brought the car in to be looked at, every time it left, every time it broke down, give me the date, give me the location, if her son was in the car with her, right? At the time it happened, the cost of Uber home, all of those things should be put in there. And if it's as vaguely detailed as it is in this complaint that I gave you guys, right? This is the one we're demurring to because it's poorly done, right? Plaintiff purchased Honda Civic from Honda Ceremony, right? But give me a date, a price, new use, address, right? Monthly, could you give me the specific dates, right? These are all things you could attack in a weak complaint. So for her brand new car was out of service for some time. Could you give me some time? If it's just 24 hours, that's not really a terrible thing. If you give me every single date and timestamp, right, that could add up. The dealer never helped. Well, could you be more specific about that, right? These are all things plaintiff notified, right, in writing or email, right? Because I'm sure in the contract is a specific way to address how to tell the dealer, I need my $17,000 back or give me a replacement car. Even in the law too, if you look at the Beverly Song Bird law, it does say that there is a proper way to notify the requirement that buyer must notify the manufacturer directly pursuant to paragraphs 1 and 2. So yeah, there's two sections here on how they should notify um, the dealer or the original location where they purchased the vehicle. If the plaintiff didn't do that, you know, it's starting to make the defendant look less and less culpable, right? So that's basically oh, thank you, Samra. Yeah, and if the defendant can prove that she didn't use certified letter, right, you potentially could have this case thrown out, or judge might push it to arbitration. Like they might not take this case, right? So that's roughly what it looks like. And let me just show you again how the memo of points and authorities is filled out. It starts with a summary of the case up here, right? And you want to be as detailed as possible. I know I give really short statement of facts or paragraphs. It's normal for it to be lengthy. It's normal for a statement of facts to be very verbose with dates and prices and details, right? Especially if you're the hurt party. You want to put it all in there and document all of it. And then in this case, though, because I gave you such a weak complaint and it didn't even give a citation, you don't even, in one way you could attack a technicality is to not even give the court the citation and say, well, what consumer warranty laws are they talking about? Right? There are many, and they didn't prove or they didn't have any allegation saying the defendant broke a law, right? And then, of course, you have to also make it clear in question form. I did plaintiff properly state in detail how defendant Honda broke consumer warranty laws, and then you could describe in detail. I know it's a short paragraph, but describe in detail. No dates, no prices. Everything was insufficient, right? Not proving, not alleging the defendant's guilty of anything. And those two sections are normally filed with the court, served on the other party, because they have every right to prepare for that demurrer hearing. The plaintiff and their counsel has every right to have time to determine what their argument is going to be, right? What their comeback is going to be. It could even be petition to amend the plaintiff's complaint as well. That could be their response to being served a demurrer and knowing that they have a demurrer hearing coming up, right? That could be, and if the judge grants it, then plaintiff could amend the complaint, but then defendant could come back with the proper defendant's answer, right? If they're given the opportunity to amend it. So demurrer, like I mentioned, even though I did take some time to explain this, right, is only used in California and Virginia. It's not used in any other jurisdiction because it's rare. It's rare. A lot of judges will probably have a plaintiff amend it, right? If it's a poorly written complaint, especially if they're representing themselves. Um, some judges can be cold and just have it thrown out, right? But they could have them amend it. That's normally granted if they ask for it. Or this is a demurrer can also be very strategic, right? If your boss could find a loophole in the laws that that the plaintiff's complaint is addressing, right? Maybe a defendant um, can claim immunity, right, or something like that. Besides, not meeting every element, that's another one too. A great way to make more money off of your client. Yes, so a demurrer is basically almost identical to a motion to dismiss. That's why we don't use it anymore. And on the federal level, it's never used. It's not even a pleading that's accepted. There's not even a template on it on the federal level. So a demurrer is very similar to a motion, right? And I figured we have 10 minutes left. Let me go over motion, what a motion is. Okay, so similar to demurrer, but there's so much more you could do with motions. Okay, let me put these motion slides. Again, these slides are up on Canvas, but let me give them to you guys. Here, I just wanted to go over what a motion is. So I'll let you guys finish that exercise for homework. I think I had it due October 1st, but I will give you guys my draft as well, so you have that to follow on. Okay, so motion is the same. Not the same, close. Close the same because when either plaintiff or defendant can file a motion, and a motion is basically asking the court to intervene to do something, right? Maybe the other party is being difficult and you need them to order, or the court to order something on the other party, right? Plaintiff or complaint, plaintiff or defendant can file this. They're called the moving party. The movant is normally the one filing the motion, right? Declarant is the person swearing under penalty of perjury, right? So you'll see that in motion documents. It'll say movant or declarant, but normally it's called the movant, right? And the respondent is the party that's responding, not filing the motion, but responding and showing up to the motion hearing, right? And you also will have to, besides the title page, a notice of motion giving the other party the date and the location of the hearing. You also have to fill out a similar memo of points and authorities, right? The laws regarding this issue, as well as like your arguments that you're going to argue at trial. I'm sorry, at the hearing, right? At the motion hearing. And I just wanted to put here declaration versus affidavit. Declaration and affidavit are the same thing. Normally an affidavit though is like notarized. A declaration, they're both under penalty of perjury. They're both, for example, if you don't have like concrete evidence, if you don't have a police report or medical receipts, you have a witness testimony, right? That's a declaration. If it's notarized and authenticated, it's an affidavit. A lot of jurisdictions will only take an affidavit. Some will take a declaration, but it's sort of set in stone when it's authenticated with a notarized witness testimony. So notice of hearing on the motion. Again, the moving party, the movant, will go to the courtroom first, either call or go on the website to see what calendar dates are free for a motion hearing, right? You get the date, and then you put it into your documents. You file the documents with the court and you serve them on the other party. So that's what happens. And then at the hearing, the judge makes a decision. If they still need to review the documents a little bit more, they'll render a decision later. And so nowadays you could go into an online portal and look at the judge's ruling, right? Before I had to call a phone number to see what that ruling was. And that might be true in some obscure jurisdictions, but now you could normally go into an online portal. Right, so ex parte and inter parte, someone had a question about this before, and we'll work more with this, examples of this too. Ex parte means out of the parties, which means only one party has to be present at the hearing. This is true if it's an injunction, a motion for injunction, or a restraining order. That's possible. Sometimes only one party has to be there, or sometimes the other party is supposed to show, but if they don't, the judge automatically grants, for example, the restraining order on the party that did show that's asking for the restraining order. Ex parte in Latin, it just means out of the parties. It's a good way to remember that only one party really has to be present at the motion hearing. Ideally both, but they can still render a ruling even though there's only one party present. And then inter parte, that's always between two parties, right? Both parties have to be present for that. In civil court, that's normally how it's done. Otherwise, the judge will probably side with the party that showed up. Right? Proof of service, like I mentioned, so you have to get the date, fill out these forms, serve it on the other party, right? So the other party has to be served 16 days prior to the hearing. Your documents, if you're the asking moving party, have to be filed 16 days prior to the hearing, right? The responding party that now finds out, oh no, we have to be present for a motion hearing on something, right? They get to file a response 9 days prior to the hearing, and any additional responses 5 days prior to the hearing from either party. Okay, so list of motions, and I had you guys had this in your homework reading. And I did notice, oh, I also forgot to address that. I noticed some links were broken on Canvas. I re-uploaded everything. Let me know if any links don't work or any Word docs or PDFs don't work. I don't know. Canvas was glitchy. But yeah, let me know if you can't see anything. But I cleaned everything up. So list of motions, right? So there's many motions. These are just 4 minutes. Okay, so these are basically some of the motions you could file, right? So let me quickly go over them. Motion for a more definite statement. So that is if in one of the pleadings or exchanges between a party during discovery or even during the pleading stage, the complaint defendant's answer stage, something is vague or insufficient, right? You could ask the other party to rewrite some portion of their pleadings, right? Or whatever messages were exchanged during discovery, if something wasn't clear, you could always motion for a more definite statement. That's what that is. Because sometimes a lot of information is exchanged during discovery. Yeah, sometimes instructions won't be that clear if they're in a hurry, right? Motion to amend, right? That's an option too. You don't necessarily, the judge doesn't necessarily have to grant opportunity to amend a poorly written complaint or a defendant's answer. You could motion to have it fixed if you notice that it's pretty weak when the other party tries to attack it, right? So you could motion to have it amended. Motion to strike. So I'm sure people have heard this in court. You could strike something from the record, right? If counsel from one of the parties says something that the jury shouldn't have heard, because prior it was discussed, we're not bringing in that evidence into this courtroom. But let's say one of the counsel tries to bring it in anyway, or they try to bring in hearsay, right? Motion to strike means have it struck from the court transcript. Right? It'll just be like not deleted, but there'll be like hyphens in the court transcript if that language is not supposed to be in there, right? Limine is common in discovery when one party asks the other party for a ton of evidence. When this case, let's say the incident took place 2 years ago, they're asking for information from 5 years ago. That's burdensome on the other party. They could motion to limit the amount of documentation they have to photocopy for you and give to you, right, in discovery. Like change of venue. I'm sure people have heard of that one. Scott Peterson got moved out of his venue, right, because there was too much bad press against him in that area, right? So they don't always grant it. The court might not grant it if it's too burdensome on the current jurisdiction, but they might allow it, right? Motion to compel, that's also a common one. When exchanging information to each other and evidence during discovery, if one party won't fork over emails that are relevant to the case, you could ask the judge, could you force them to give me those emails? Because it's relevant to the case, right? And this is discovery. They're supposed to readily exchange information with us. A protective order. Oh, okay. Protective order is to limit discovery. I didn't realize limine. So motion in limine is, yeah, is when you want to not have evidence presented in front of the jury, right? So this is normally discussed. I flipped these. Sorry. To limit discovery is what I mentioned prior, right? Motion in limine is when there's a damning piece of evidence against one party or the other, and they're fighting to have it struck from the record or not even presented at trial at all in front of the jury. So that's what limine is. And then motion to dismiss, right? That could, instead of a demurrer, more than likely an attorney that you work for will probably ask you to draft documents for a motion to dismiss, to request a hearing date at the local courtroom for a hearing on a motion to dismiss versus a demurrer, right? So that's why it's not used often anymore. A summary judgment is kind of the same thing, but it's done later on in discovery. What is a motion for summary judgment? I'm sure you guys heard that a lot on TV and stuff. A motion for summary judgment is when one party thinks that they have enough evidence already at this point in time before we get to trial to win this case. I have enough evidence that was collected during discovery to prove that that defendant did this, right? Or they did not do this, right? And normally a motion for summary judgment is done during discovery, and the court will also publish a ruling in your favor. A motion to dismiss just throws the case out. There is no ruling in your favor. It's just thrown out. It's not acknowledged by the courtroom anymore. But a summary judgment will get a court order or a ruling in your favor, right? You won the judgment. So now if you're the plaintiff, you could collect money, right? Motion for a directed verdict. That is usually if the plaintiff or even if the prosecution did a very weak and not convincing job of proving to the jury that the defendant is guilty. Counsel for the defendant or the defendant themselves could motion for a directed verdict. I don't think they proved beyond reasonable preponderance or reasonable doubt that I did this. Right? And then motion for these 12 and 13 happen after the verdict is read. Right? Motion for a new trial. Most people do a notice of appeal instead of a new trial because this has to be filed right away. And normally to ask for a new trial, you have to prove that there was an error that the judge made during the proceeding. And if they can't do that, you have more time to do research on what mistakes the judge made. Notice of appeal, I think you have 60 days. I think for a new trial, you only have 14 days after the verdict is read. That's why normally people file a notice of appeal instead. And then notice to set aside a judgment. Judges rarely set aside a judgment. They can set it aside when you're filing a notice of appeal, or they can set it aside if they really don't agree with it. But a judge normally concedes to the jury. Like if they say that the defendant is guilty, right? The jury normally won't. The judge normally won't go against that, even though people don't know this. They do have the right to do that. oh, oh, we are at time. Okay. Can the party argue motion to compel during? Not during the trial. Compel is normally done pre-trial during discovery. But yeah, a lot of these, like motion for directed verdict, that can be done during trial. Motion strike, that can be done during trial. Dismiss. Yeah, I think those two could be done during trial. Otherwise, everything is normally done pre-trial. You guys, if whoever has to go, if you're free to go, I'm just going to answer questions, and I will post my draft that I was filling out of my demurrer to help you guys out for homework, and I'll post this recording too. Let me just answer some questions here. Can a competency motion be made during pre-trial? Competency in terms of a competent counsel? Gabriel, let's see. Is that what you mean by that question? Oh, I'm sorry. Here, let me give you the opportunity to unmute yourself. Oh. Motion for incompetence. I'm assuming you mean for counsel, your attorney or their attorney. Oh, incompetent defendant. Rebecca, oh, you need study aid templates for pleadings. I could do that for you guys. I could give you customized ones and I can give you templates from the website themselves. Can I say and ask you a question about another? Oh, sure, Janelle. Sure, no problem. Everyone can, whoever has questions can stay. Um, an incompetent defendant. Oh, let's see. Because I thought you meant competency motion, because it could be made on behalf of the defendant if the attorney that comes in to present that represent them isn't doing a good job and is clearly out to lunch. um, they normally could fire their counsel during the trial. But I've never seen any income self-representing. Oh, okay. So to sort of do that I've never seen. I'm gonna have to do some research on that. That's a great question. An incompetent defendant representing themselves. Yeah, I didn't know that you could do that for your attorney if they're doing a poor job. And then you can sue them later for legal malpractice. But as for yourself, I wonder due to documented disabilities. I don't know if the plaintiff, well, I mean, I'm assuming the plaintiff would be the one filing that, right? Not um that due to documented disabilities. I don't know if a court would continue on knowing that there's that much of a disadvantage regarding a defendant's disabilities. Although I've never seen like a plaintiff file the motion for incompetence. I'm gonna have to do some research on that one for you too, because so I had a question about can a demurrer be filed later regarding or a motion to dismiss, and then yeah, an incompetent defendant that I've never seen a plaintiff do. Definitely could do it for your counsel if you feel like they're doing a poor job. Um, oh, the defendant files it on themselves. Is that the question there? Um, oh, um, I had to look into that for you. Like, yeah, I'm not really sure. So if they file it themselves, because I'll be honest, I've never seen that one come to my desk, but I could definitely look it up for you. Because you could definitely do it on an attorney.